So we now move on to our part of the program where the guest speaker will talk about Constitution Rewriting Theory and Practice. Our guest speaker, Dr. Kimana Zulueta-Fülscher, is the Program Manager for Democracy, Conflict and Security Unit of International IDEA. She has a PhD on Political Theory, Democracy and Public Administration from the Universidad Autónoma de Madrid. The International Institute for Democracy and Electoral Assistance, or IDEA, is an intergovernmental organization with a mission to support democracy initiatives worldwide. During her talk, Dr. Fülscher will introduce a practical guide to constitution building, as well as the Constitution.net website, where users can find all knowledge resources produced by International IDEA dealing with design-related issues such as federalism, bicameralism, constitutional assessment, constitutional reform processes, and the role of political parties, among many others. Let us give a warm round of applause to our guest speaker, Dr. Kimana Zulueta-Fülscher.
That's just how it is. Thank you very, very much, Professor Felix and Professor Ferrer, for inviting me and giving me the opportunity to actually present our program, the Constitution Building Program within International IDEA. I need to excuse myself because my voice, this is not my usual voice. The air conditioning took the best part of it. But I hope you can hear me and it's not too painful to listen to my voice for the next 45 minutes, which is what is going to take me to actually introduce to you some of the knowledge products that we produce at International IDEA within the conflict, within the Constitution Building Program. So I've already been introduced, so I don't need to do that for myself. Is it okay with the sound? Is everyone listening to hear? And International IDEA has also been introduced, so maybe I can skip that as well. And I can go immediately to the overview of what I'm going to talk to you about today. Thanks. So, International IDEA is actually, as was said before, an intergovernmental organization. It's 20 years old. And we work not only in constitution building, but also regarding electoral processes, public participation, and representation. And also a bit of a wider program on democracy and development, which deals with issues related to service delivery and accountability and the management of different public policies. Now, the Constitution Building Program was created actually in 2003 when the institution actually realized that constitution building is such an important part of any democratization process. And it was at the time actually the first institution that had a whole department dealing with constitution building issues, and it continues until today, although there are of course other organizations that deal with these issues as the leader in the field. And just so you know, constitution building focuses on three different areas, or three different working areas. The first is, of course, it develops knowledge resources, not only for constitutional design issues, but also for the entire process of constitution building. And we see the process as much bigger as only drafting the constitution, but it also, especially in post-conflict context, it goes from basically the decision on a ceasefire agreement to actually the final constitutional draft. But we also give advice. We've been very much engaged with different countries, from Bolivia, Ecuador to Nepal. We've collaborated with the constitutional drafting assemblies. We've collaborated very much with the government of Chile to help them actually decide on how best to do their civic education program and public participation campaign, because they are engaging right now in a constitutional reform process, very interesting at that. And then, of course, we also do trainings of civil society actors of how to engage a constitution building process. We've done that in Ukraine and in Afghanistan, although, of course, there is no constitution building reform there, but hopefully sometime very soon. And regarding the development of comparative knowledge resources, which is what I'm going to focus on most of my presentation, I'm going to tell you a little bit about knowledge resources in the field of design issues, but also I'm going to talk to you about some of the knowledge resources that we've developed related to the entire process of constitution building. So related to design, I will present to you 3 products today. So not only the practical guide, which was published in 2012, but also the follow-up constitutional primer series. And finally, the Constitutional Assessment for Women's Equality tool, which might be interesting to some of the participants here today. These knowledge resources critically stress 2 issues, which are very important to keep in mind for any constitution builder or any other expert that is interested in these issues. First is the importance of context. And there cannot be one-size-fits-all approaches when you engage in a constitution building process. Even when you bring external experts, one-size-fits-all approaches usually do not work. And the second is the fact that constitution building processes need to be nationally owned. Of course, nationally owned can mean a lot of things. International IDEA actually tries to expand this nationally owned, not only to, of course, political elites, but also to the broader public. So let me tell you a little bit about the practical guide on constitution building. The handbook was, as I said, produced in 2012, and it includes 7 different separate booklets. First, an introduction, a booklet on principles and cross-cutting issues, another one on human rights, and then the 3 state powers, the executive, the legislative, the judiciary, and finally a booklet on decentralization. I'm going to present them to you very, very briefly so that you get an idea of what these booklets actually deal with. I have a copy over there if the university doesn't have one. In any case, if the university considers that they could need more, we're always happy to send them to you. So the introductory chapter basically aims at making the decision maker aware of 2 concurrent issues. The first is that reforming the constitution is really not only about content issues, whether the country will remain presidentialist or will move towards semi-presidentialism or parliamentarism, etc. But that an essential part of any constitution reform process is actually the process through which this constitution is going to be reformed. And so the decision maker needs to actually decide on a number of issues, which might include what the drafting body is going to look like, what is the timeline, what is the decision-making structure, etc. The second issue that the introduction very much deals with is the challenges that the decision maker is going to face in terms of, or especially in conflict-affected settings, such as that perhaps some sort of peace is necessary before actually starting constitutional negotiations. And then on the other hand, you need to balance both peace and justice, as we just saw in Colombia, where the referendum for the peace agreement was not passed. And some say that it was because there was an overemphasis on peace in the short term, and that challenged the overall process. This is, of course, up for discussion, but it's one of the ideas. So the second booklet on principles and cross-cutting issues, very briefly, explores 3 issues. The first is how constitutional principles emerge and develop, and then how they are incorporated into the Constitution. Either they are incorporated into the text, or they are the effect of, or the result of the constitutional interpretation or constitutional implementation. And finally, how do these principles actually get ingrained when looking at different principles like democratic governance, or gender, or diversity, or religion, or even international law? The third booklet on building a culture of human rights basically deals with the reasons why we should incorporate human rights into a constitution, but also what types of human rights and how should they be incorporated. And this, of course, needs to be very much in touch with the specific context of the country in question, but also might be the result of a decision to make the constitution a transformative constitution. A constitution does not necessarily need to be only procedural, but it can actually move the country towards another state where it was not before. This booklet also deals with the impact of actually incorporating human rights into the constitution, into the overall context, or actually the constitutional process. Because incorporating some of these human rights into the constitution can sometimes be a little bit controversial. Like, for instance, the right for life. When you oppose it to the right to abortion, it's controversial in many countries. Or how do you define the right to marriage? Do you need to define it in the constitution? Does it need to be actually incorporated into the constitution? And the third thing that this booklet deals with is the type of factors that constitution builders need to take into account before, actually, or ideally before, incorporating human rights into the constitution. And those are how human rights might actually be enforced, so that the constitution is not only a piece of paper, but actually gets implemented. The next three booklets deal, as I say, with the three branches of government, and I'm going to pass through them really very brief. So on the executive, the booklet deals with, or helps the decision maker actually understand what governance system the country in question will want to execute, whether it will have a presidential system or parliamentary or a hybrid system. And then this booklet very much deals with how would you limit the executive power. And there are different options as to how to limit it. I won't get into detail here, but you can have a collegial executive, an executive with different personalities. In Sudan, for instance, there was one president and there are two vice presidents. Bosnia-Herzegovina is also an interesting example, although not very successful, of course, but where you have a rotating presidency, ethnically based rotating presidency. And of course, Switzerland would be sort of the case of collegial executive. But you can also have a dual executive. This is especially so in semi-presidential systems where you have a president, but you also have a prime minister, and these two figures have some sort of an equal level of power. And this is usually in semi-presidential systems, as I say, but it might also happen in countries where after an election, where there is conflict after an election, and there is a presidential system, but then they include a prime minister to actually equalize the powers of both the government party and the opposition, like has happened in Kenya or in Zimbabwe. And then you have, of course, presidential term limits that you know very well here in the Philippines, where your president can only serve for one term. Or actually decentralization, which is another way of actually limiting the power of the executive. And then the booklet goes into more formal and substantive powers of how actually the executive can be limited in its power vis-a-vis the legislative. For instance, can the executive appoint or dismiss the head of government, or does it have the ability to actually dissolve the legislature, etc. So in terms of the design of the legislature, the booklet basically first makes the decision maker actually understand the three functions that the legislature usually has in any country. Of course, it is a representative body, but it is also a lawmaking body as well as an oversight body. And understanding this, the decision maker needs to make a decision on whether or to what extent the legislature will have some sort of degree of autonomy. And here we've already talked about the power of the legislature to actually limit the powers of the executive. But then also the decision maker needs to decide on a number of issues from the electoral system that will be used to actually elect the legislature, whether there will be a second legislature. Here in the Philippines you have a second legislature. The identity of that second legislature might need to change if you move towards a federal system. The decision-making structure of the legislature, etc. So these are sort of the formal and the substantive powers that need to be decided upon. And in terms of the judiciary, The booklet deals first with judicial powers, including constitutional review. In terms of course, the judiciary is usually thought of as settling disputes or interpreting the law. But when you move from a unitary to a federal system, the judiciary might need to resolve disputes between the federal and the sub-state or regional level. And the court needs to have an identity of either only responding to concrete cases, so be case-based, or actually have an advisory role. But in any case, the judiciary in any federal state will have to increase its workload because it needs to decide on all these disputes between the federal and the regional level. Then it also talks about judicial independence. I'm not going to go into it very deeply, and legal pluralism, which is the coexistence of multiple legal systems, which might be also interesting for you in terms of that. The Bangsamoro, as I understand, has also, or appeals to having also some parts of the law responding to Sharia. Finally, the booklet on decentralization. It takes on the dispersal of government from the central authority or from the national center to other levels of government. Where decentralization actually not only involves, and this was very much stressed in the conference that we just came from yesterday and the day before, it is not only about giving autonomy to subnational levels of government, but also allowing subnational entities to be involved in national lawmaking. And there are different ways in which you can organize this. You can actually have a bicameral system, so second chamber, Senate, which you have already, but this might be, need to be reformed, as we said before. Or you can have concurrent powers that allow various levels of government to regulate a specific area together. And in this sense, the guide adds a number of questions that constitution makers need to bear in mind in order to know what type and form of decentralization they would want to establish for their country. And these include how many levels of government? Will you only have a central government and a regional government, or will you also have provincial level governments or local level governments, and will these all be constitutionalized? What will be the boundaries of your territorial units, and what criteria will you use to actually decide on these boundaries? Will it be all identity-based or ethnically based, or will you actually also take into account the efficiency of the government? So does the sub-state entity actually have the means to become autonomous, or will it depend on the central authorities for its subsistence? Also the depth of decentralization. So will it be only administrative, or will it also be political and fiscal? Will it be symmetric, so will all different subnational units have the same juridical status, or will it be asymmetric, like we have right now in the Philippines, where different regions have different degrees of autonomy? And then, of course, what legal safeguards? So will the state be defined as federal, or will it be a decentralized unitary state? And of course, a federal system is not synonymous with decentralization or with autonomy. You can have a unitary state that is much more decentralized than a federal state. And an example of that is the UK. The UK is much more decentralized, for instance, than a country like Sudan, which is actually a federation. So what actually defines federalism is that the fact that intergovernmental relationships, so the relationship between the center and the regions, is actually legally defined. So this would be it for the guide. If you have any questions, of course, you're always available to respond to them. The guide is actually downloadable on our website, so please feel free to look for it. Now, when the constitution-making body sits around a table to negotiate and decide on different design issues, usually tension arises not on very big issues, but rather on very small issues, or relatively small issues. Like, does the executive have veto powers? Or is the head of the executive able to dissolve the legislature? Will there be judicial tenure? And all these kind of smallish decisions that need to be made within a constitution. So in 2014, the Constitution Building Program decided to drill down on some of these key design issues by producing a series of primers on topics of interest to constitution building that are very much related to these very specific design issues. And we actually consulted the United Nations in terms of helping us decide on some of these priority themes. And while the series is still in production, we have already 16 primers on topics as varied as bicameralism, constitutional amendment procedures, judicial appointments, executive veto powers, social and economic rights, as well as federalism. So, as I will not have the time to actually go through everyone, to your luck, I won't be able to go through every one of these primers. Maybe let me walk you through the structure of the primers for using the primer on federalism, which might actually specifically interest you. So the primer is basically structured along the following lines. It first defines the what. What does federalism mean? And federalism, the primer says, is a system of government that establishes a constitutionally specific division of powers between different levels of government, as we were saying before. The primer then turns to the why.